said. I have heard the directions of the bench. The file is not before you. But I have instructions for the purpose of the work to take that petition was filed on 18th of October. The same day the Kerugoya file were filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours are borders. The reason as to why Kerugoya files before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lords. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has heard me loud and clear. Thank you.
And my lord, if you could mourn elsewhere.
I had indicated in this honorable court that there will be at least 3 clarifications.
Just a minute, Mr. President.
I think we need to get some things right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that we are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why you are here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My Lord,
Just a minute, please.
Perhaps just to add that the numerous other petitions that are coming up, I think the process is ongoing. Maybe not all the files have been transmitted to the bench. Maybe by the time we leave this courtroom, other files will have been transmitted to the bench. But as we speak now, here and now, these are the only files that were transmitted to the bench and in which there are applications where the bench gave directions for hearing today. That is not to say that those are all the petitions there are. We don't even know whether the transmission has been done yet, and that we will go back and find all the other petitioners whose concerns are valid. Perhaps those files would now be before the bench formally so. Right?
Today. Madam Lady, for the 5th interested party in 15, may I just be heard for 1 minute only. My Lord Jandra asked an important question. How do we move forward? Now the paradox, as I got it, because I don't want to make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Mrima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity to sit, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction on the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guide and Professor Gideon Muigai, there will be greater order and coherence. And I thank you.
My Lord, is that an adjournment? Is that Mr. Ongoya applying for an adjournment? Because he's saying, and perhaps rightly or wrongly, that even the recusal application comes after determination of the question of empanelment. If that be so, and they may leave, they normally leave court, they left Senate, may leave court, we let them say whether they are applying for an adjournment.
Is that remark, they normally leave court, they left Senate, my palatable in this court, my Lord? I need that.
No, because this is an adjournment.
No, is that remark palatable before my Lord and my Lady? But because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then there's a problem. I'm urging that you direct that remark be withdrawn first, then we make progress. I'm urging, my Lord. The remark was made in your presence. I'm urging it be withdrawn first, then I can respond.
My Lord, I have no problem with withdrawing the remark, but the point is, it is a veiled application for adjournment. Because Mr. Ongoya is saying that the court must address the question of empanelment before the recusal. So why can't he just get to the point?
I am answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but I didn't withdraw. I want him to withdraw first, my Lord, because I'm entitled to dignity.
Ongoya, I have no problem with withdrawing. You're my friend, but no, I have no problem, my Lord. I withdraw the remark, but
so Thank you.
There is practice.
Thank you. Let me now address the question as addressed. My Lord, Professor Jenda was my teacher and my mentor of many years. I have no disrespect for him. I just want my own dignity asserted, because I can't protect my client's dignity if my own is in question. But having said that, my Lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues Kibe Mungai and learned colleague Mr. Ndegwa that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that regard that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Gidu Muigai, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. They'll have a determination on that question. I humbly believe.
Sorry, Chief, again,